Just Miss Hubbell's out there.
Okay. All right, we are here on the matter of Abigail Gider. We have with us today Miss Lydia Hubbell, who is the mother. Ms. Hubbell, let me get you to stand and raise your right hand for me, please.
Do you swear to tell the truth, the whole truth, and but the truth have you got?
I do.
And we are here on a motion for visits and a motion to dismiss, and a response to the motion to dismiss. Unfortunately, apparently Mr. Gider has called to the clerk's office and said that he is ill and not able to come to court
What
today.
I tell you. Could he appear by phone?
Did he leave a number?
I have his number.
All right, what's the number?
He did, Your Honor,
What's his number?
615-513-3626. He did this for our last court hearing. I knew when he did it and got away with it then, I knew he was going to do it today. I understand he doesn't want to come in and deal with this.
615-3626.
Mr. Gider?
Yes.
This is Al calling from Davidson County Juvenile Court for Judge Calloway. Please hold.
Sure.
All right, Mr. Gider. Okay, Mr. Gider, let me get you to raise the right hand for me.
Sure, just 1 second. Okay, I'm ready.
Okay.
Do you swear to tell the truth, the whole truth, and but the truth have you got?
Yes, I do.
All right, Mr. Gider, it's my understanding that you are under the weather and unable to come to court today, is that correct?
Yes.
Okay. And Ms. Hubbell has filed, you have filed, Ms. Hubbell, a motion to, Ms. Hubbell is here in court. And Ms. Hubbell, you have filed a motion to reestablish visits.
Yes.
Are you in agreement to that motion, Mr. Gider?
No, I'm not, Your Honor.
Okay. And what I'll need to do is I need to set it for an actual motion hearing. Do you plan on calling witnesses, Ms. Hubbell?
Yes, I've subpoenaed my daughter. She's 12 now.
All right. Other than your daughter, any other witnesses you plan on?
Just him and my daughter.
Okay. Do you have any witnesses that you plan on calling, Mr. Gider?
No.
All right, let me pick a date that we can come back for the hearing on this matter.
Your Honor, mother also had a separate petition filed for the same thing. I'm not sure if you knew that.
There's a petition, who filed a petition?
I filed a new petition.
Oh, yeah.
Filed a separate petition to reestablish the parenting time, like custody, and it's dated set for March 15 in front of Magistrate Robertson, I think.
Okay. So what's,
We have a separate hearing.
all right,
Laura has not had any contact with me since July 2018.
let me ask this procedurally, what's different from the motion that you filed in front of me versus the petition that you filed?
Well, the petition is for changing custody and for contempt to establish, I've got several material changes in circumstances and also but she needs, my daughter needs relief, and I also need the restraints lifted so I can do discovery for trial. Because there's restraints on me getting information from the school, there's restraints on me and I did get, the main thing I'm in front of you for is I want some clarification on the order from August 2018, which was, the petition number on that was the DCS case, which was dismissed it was voluntarily dismissed, I think in April of 2019. And the other number on that order, August 18th, was my emergency motion for custody, which I dismissed in October 2018. So my question is that August 2018 order, which cut me off from all contact with my daughter and the school and the everything, is that still in effect? Because this, the situation we're in right now is against public policy. Now, Dolores' dad's had complete control of her for all this time, and he's not going to give it up easily. So
Mr. Gider, is there still an order of protection?
between me and him, yes.
The order of protection is on me. I'm protected child. There is no order of protection for the child, but there is a restraining order from a circuit court.
Which you have control over that restraining order, unless it expires after. I don't know if the restraining orders expire.
No contract order was issued by juvenile court for my motion. Yeah, I filed a motion for no contract, and that order was issued for my motion, not for juvenile DCF motion.
All right, so basically, from the last time we were here, as part of the hearing, April of 2019, I found that the final adjudication of petition 233-886 and 232-962 was disposed on April 19th of 2018. Mother's visitation was suspended shortly after. Mother's motion for a new trial was denied. Mother filed an appeal to Court of Appeals on October 25th, 2018. Therefore, all matters in the court are resolved. Court will not entertain a change in visitation until after the Court of Appeals has made a ruling. They made a ruling and confirmed motion. And then furthermore, mother and father's appointment of custody leave was all in the So, for clarification, whatever order was previously done in 2018 is what you all are to abide by. And that order has been, I think, affirmed by the Court of Appeals, and so that is what you are operating under. There was the order that plus the order that suspends the visit that happened after that.
And so part of the problem is that order required in-home therapy, and he terminated that in June. So
I'm not going to hear all this stuff now. I'm going to set it for a date when we can actually have a trial.
Okay.
Mr. Gider, is it, you don't have to tell me what's wrong with you, but is there a time period that you're going to be able to come out?
And one more thing, Your Honor, also Mother Hubbell is filing appeal with the Supreme Court of Tennessee, so if it changes anything, I'm not sure. So she's gonna file an appeal with the Tennessee Supreme Court.
Have you already filed an appeal?
I haven't turned my application in,
Okay.
but,
I'll go ahead and set a date for a hearing this. If she does file, then it's just still gonna be the same thing, we just hold off until after they make their.
well, Your Honor, that's actually not, I put in he did his motion to dismiss, but we've got, we're going to be going in front of Judge Robertson for this new petition. So when starting a new case, will Judge Robertson have, I put in my answer to his motion to dismiss the law about how the court still has the authority to act in the child's best interest even when something's pending in the appellate court. Let's see what page that was on in here. But I'll just tell you, he's going to do anything he can to deny Delora any contact with me.
Mr. Gider, you filed the motion, so I do need to hear that motion. Is this a illness that will be over soon, or are you in some type of isolation, or how soon can I set this motion for the hearing?
Yeah, what date you have your order? I can tell you whether I can come or not.
So I actually have, on Monday, I'm available Monday.
Do we have anything later than that?
I can look, it'll probably be a while before I have something after that.
I think he should have to bring a doctor's note in, because I've got a feeling he just just doesn't want to come in, because he called in sick on the 28th of September as well. He's not going to want to deal with this. I'm just telling you, he needs to be required to come in or have a doctor's note. I have never missed a court date in all these years with being chronically ill. I'd like to come in on Monday because,
You don't have anything set December 3rd?
As of so far, the actually appeals we have coming up this Thursday are the first ones, and the third, we moved that. Because at one time, at the beginning of last year, I had a quarterly administrators meeting.
Gotcha.
So our appeals will now be on the 10th and the 17th.
Oh, gotcha.
Instead of the 3rd and 17th.
Okay, so I do have the 3rd open.
That is correct.
All right. I do trust you, that's what I do. All right, how about the morning of December the 3rd?
December the 3rd. Yeah, I can make that date, yes.
Okay. Ms. Hubbell, can you make that date?
I can.
All right.
I certainly can. I would have rather taken care of this on Monday, and it's not going to take a very long time.
All right, we will be back then on December the 3rd. You want to do? Hold on just a second, let me make sure that that, she doesn't have to be on the newspaper, on the motion, on the motion.
Yes. Hold on one second, please, sir.
Sure.
I expect he's hoping he can find a lawyer between now and then who'll help him do this. And if he doesn't, I expect he'll be sick again.
Good morning, Ms. Mack. Al Stetstill, Davidson County Juvenile Court, on behalf of Judge Sheila Calloway.
Yes.
Do you have your calendar in front of you, please?
What am I reading, such a device for?
To let me know if you have a date available.
Okay. Is there something I'm supposed to be in court for?
Let me get you back on the record.
Your Honor, why, she was appointed because of
Hold on, Ms. Hubbell.
Mr. Gider?
Yes.
Attorney Mack?
Yes.
Okay.
So, Ms. Mack, there's a lot going on with the Hubbell-Gider matter. Ms. Hubbell has filed a petition for a change of custody and parentage. That petition is not what I'm calling you about. You're not appointed on that case, and you're not obligated to appear on that case. That is going in front of Magistrate Robertson sometime in March. So that is not why we're calling you. I am calling you because she has also filed a motion as to her visits and some clarification as to the order that was done back in
2018.
that I did, that you were a part of that case. She is filing a motion in that order to make some changes. Because you were a party at that, as a guardian ad litem at that time, you do have to be on the office. There's also apparently there was you were supposed to draft that final order, and I don't see that in the file. Sorry about that.
What final order was I supposed to draft? When was that?
That was,
October 2018, or, no, it's April 2019. I think it was April 2019.
yeah, that was for April 9th of 2019.
Can she withdraw?
Yes, we all know where I was during that time, but that's okay. All right.
So I have selected a date to have a hearing on that matter. Let me tell you exactly what her motion for today is.
I'll forward her a copy of it. I'll email her a copy of it. And his, and,
Let me find it. Her motion today, I'm gonna read it to you line by line. Oh, he's gonna forward it to you.
oh, good, then I don't have to. You might want to
The
send,
bottom line, she wants me to clarify that order. Define the father has interfered in the mother's relationship with the child, establish visitation, and grant mother exercise of non-custodial rights, and restore the mother's right and remove all restrictions.
So, okay, so we're asking for you to clarify that she's only to have what she's had for the past 2 years.
Correct.
In regards to visitations, we're asking for you to clarify something that we already know.
there's been
She wants
changes.
us to establish visitation and grant mother exercise of non-custodial rights.
Well, I want to know if
I
that,
think,
But I guess because I'm confused because you can't grant something until she's done what was required of her to do.
correct, I agree with that, and so I guess when we come back for the actual hearing on that, I'll just need to see whether or not she's done the things that she was required to do by that order. And, depending on if she's done the things that she was ordered to do, how quick the hearing will last.
well, my question was, is that,
Basically, look, I just want to be clear. So basically, at this point, even though all of this is kind of emotions from in regards to what your rehearing has stated, and the rehearing on that, the same thing, so every time we come back, we gotta come back before you are, because I'm just trying to make sure that I'm understanding.
Well, we have to come back, if she filed something on that motion for my court, yes, we have to come back on that. But she also filed a new petition, you would not be required to come back on that big petition, because you've not been appointed on that, and that is not a neglect dependency matter.
Okay, good.
But because you are the guardian ad litem, or were the guardian ad litem on this matter, and that's what she's asking for me to look into, which I think is a bottom line of reading the order, seeing what was in the order of her requirements of to do. If she's done the things that she's supposed to do, then it's just, a matter of, if she's done it, then she probably does get visitation. If she hasn't done it, she doesn't get visitation. That's pretty clear on the order.
well, my question was about,
Does her motion even say that she's done those things and request for those things?
No, ma'am.
but those petitions, those underlying petitions were dismissed. So that's what my question is if the,
I guess what I'm confused about, Your Honor, is the mother has gone to the appellate court in regards to this. Is everything complete in the appellate courts right now?
Yes, the appellate court, she has, the Court of Appeals, did their order where it affirmed the decisions of this court. Now, according to Mr. Gider and the mother today, she has an application that she's going to file to,
To the Supreme Court, so she's
Yes.
going, that's what I'm saying, so
and so
I'm confused.
so she has not done that as yet, and so what I have said again, if, she does, if it does go to the Supreme Court, then I would agree, there's nothing I can do on the case as of right now. Now, she can go forward on her new case, but nothing on this case. Until there's a final ruling from the Supreme Court. But regardless, I'm gonna set it for a little hearing. And as the guardian item on that case, require you to be here. Are you available on, December the 3rd in the morning? And I'm gonna put a limit of an hour on it. Cause she's only asking for, the child to be a witness, and that's it.
And the father.
The child and father.
And Your Honor, I guess the issue that I have is just basically sounding like she's asking for you to rehear what you've already heard and made a decision on.
No, that's not what I'm
And
asking.
was already made a ruling on.
So, yeah, I'm
That
not
doesn't
gonna
have,
do anything.
yeah, that doesn't have anything, my new motion has nothing to do with what's going on in the Court of Appeals. It's the underlying petitions are gone, and
To make
he's,
sure that we're clear, what I'm going to do on that day, when we come back for hearing, is I'm gonna clarify what the order was as to what you had to do in order to reestablish your visits. And then if you have done those things, then we will look at reestablishing your visits. If you have not done those things, then that hearing will be over, and you can, the rest of the stuff, you can argue on your new petition.
but I cannot comply with the services because he terminated them in June. That's part of the contempt in Robertson's. So I'm not asking about, we're not regurgitating the same old facts.
If that's part of the contempt, then I probably just need to wait to hear this after the contempt is done.
Well, then it still leaves the question of if an order is attached to petitions that were dismissed, does the order go away?
No, clearly what the order says, what I just read to you, is that those two petitions were gone away, but the other order was still in effect, and the suspension of the visits was still in effect. So I clarified that. We'll make sure that Ms. Mack gets that memorialized in writing, and that's clarified. So if the only other issue is whether you have done the stuff that you were ordered to do, and you have not, but you're saying that it's his fault, then that's on the contempt issue that needs to be heard by Magistrate Robertson, and so there would not be anything for me to hear at this time until after that's been decided. So I will just put this on for status for a check after the date that the contempt is set, and that's set in March.
March 15th?
So I'll put this on the motion document after that time. Which is that, so we got enough time for that?
Oh, I'm sorry, what date did you say,
It's after March, the motion document after March 15th.
after March 15, 2021?
Yes,
So we're not going with the,
we're not going with the other day.
okay.
March 23rd.
Hold on 1 second, February, March, after March 15th, March 23rd at 9 a.m.
All right, so I'll put this on March 23rd at 9 a.m. after y'all have the contempt hearing, and we'll go from there.
March what? Oh, thank you.
All right, any questions? So you all don't come on December 3rd. We'll hear this, y'all will go through the consent process at that time, and then we will hear the results after that. All right, any questions, anybody? Thank you. Ms. Mack, you'll make sure you get that.
December 3rd?
No, yeah, do not come on December 3rd,
Okay, good.
but we will come back on March 23rd at 9 o'clock. Is that right?
Yes.
Anything else at this time? All right, that'll be the court's order. Thank you, Ms. Mack. Thank you, Mr. Gider. Thank you, Ms. Hubbell.
Thank you.
Thank you.
Hold on, don't you say a word.